Hey everyone, welcome to The Law Explained. I'm glad you're here, because today's topic is one that could literally change how you handle one of the scariest and most confusing moments in real life. We're talking about what happens if you refuse to show ID to the police. They won't tell you this, but you deserve to know. This is about what's really legal, what's not, and how things actually play out on real American streets. So sit back, take a breath, and let's walk through the law, the fear, and the truth together. Imagine it's late evening. You're walking home after visiting a friend, the streetlights humming softly above. You're not doing anything wrong. Then from behind you, you hear the slow roll of tires and see the glow of headlights bouncing off nearby houses. A police car eases up beside you, its engine low, its presence heavy. Two officers step out, flashlights cutting through the darkness. "Excuse me, sir," one of them says. "Can I ask you a few questions?" You freeze, pulse quickening. You're not sure what this is about, but you nod slightly. "Do you have some identification on you?" one asks. It's a simple question, but in that moment it feels like a test. You hesitate. Should you show it? Are you required to? You've heard people online say, you have the right to refuse. But you've also seen news stories where things went wrong. You take a small breath and reply, "I'd rather not." The officer's tone tightens. You're required to show identification under state law. Your heart beats harder. You manage to ask, "Am I being detained or can I go?" There's a pause, long and heavy. That's the moment where law, fear, and misunderstanding collide, and everything depends on what happens next. To understand that moment, we need to understand what the law actually says in the United States. Because, despite what people think, there isn't one single federal rule that covers every situation. When a police officer asks for ID, the foundation of all this starts with a 1968 Supreme Court case called Terry v. Ohio. That case established that police officers can stop and briefly detain a person if they have reasonable suspicion that the person is involved in criminal activity. Reasonable suspicion isn't the same as probable cause. It's a lower standard, but it must be based on specific and articulable facts. So, if an officer sees someone looking into car windows late at night and acting nervously, that could justify a Terry stop. During that kind of stop, the officer can ask questions and may even frisk for weapons if they have reason to believe the person is armed. But that doesn't automatically mean the officer can force you to hand over identification. The law stops short of that unless other rules come into play. In 1979, another major case, Brown versus Texas, went before the Supreme Court. This one involved a man in El Paso who was stopped by police just because he was walking in an alley in a high-crime area. The officers demanded he identify himself, and when he refused, they arrested him under a Texas statute requiring people to provide their name and address when lawfully stopped. The Supreme Court struck down the conviction, ruling that the stop itself was unlawful because there was no reasonable suspicion. The court said that you cannot be punished for refusing to identify yourself if the police didn't have a legal reason to stop you in the first place. The case is a cornerstone for understanding your rights when you're approached without cause. But then, in 2004, came Hiibel v. 6th Judicial District Court of Nevada. This case changed things. Larry Hiibel was standing by his truck on the side of a road when a sheriff's deputy approached and asked for ID after a report of an altercation. Hiibel refused, insisting that he hadn't done anything wrong. The officer arrested him under Nevada's Stop and Identify statute, and the case made its way to the Supreme Court. The court sided with the state, saying that requiring someone to identify themselves during a lawful detention didn't violate the Fourth Amendment. But that ruling came with strict limits. It only applies if the stop itself is lawful, that is, if there's reasonable suspicion, and it only means you have to provide your name, not necessarily produce a physical ID card. So the Hiibel decision didn't give police unlimited power. It allowed states to pass stop and identify laws under specific conditions. There's also Miranda v. Arizona, decided in 1966. which you've heard quoted countless times on TV. You have the right to remain silent, but Miranda rights only apply once you are in custody and being interrogated. They don't automatically cover short encounters on the street or traffic stops. So if a police officer stops you for questioning and you're not under arrest, you can still invoke your right to remain silent, but that doesn't mean they can't ask for ID if state law allows it. And that's where things get tricky. Because there isn't one uniform law across the US, it's a patchwork. Some states have stop and identify laws, and others don't. In states that do, like Nevada, Arizona, Colorado, Florida, Indiana, Ohio, Utah, Vermont, Wisconsin, and a few others, if the police have reasonable suspicion and the statute applies, refusing to give your name could be considered a misdemeanor. In states without such laws, you may legally refuse, though it might still escalate the situation depending on the officer's reaction. The key point is that your obligation changes from state to state, and even sometimes from county to county. So, what actually happens if you refuse? There are a few possible outcomes. The best case is that the officer realizes the stop has no legal basis and lets you go. It happens. Sometimes they're just fishing for information or trying to look busy. In that case, you walk away shaken but free. Another outcome is that they issue you a citation or arrest you for refusal under a valid state law. You'll have to fight it later in court. The third, more common scenario, is that they claim your refusal amounts to obstruction or resisting. Those charges are often vague and overused, and sometimes courts later dismiss them. But in the moment, they can still get you cuffed. And of course, there's the worst-case scenario, an encounter that escalates beyond words. Maybe the officer misreads your body language, or maybe tension rises too fast. You reach for your phone, they reach for their weapon, and suddenly the law doesn't matter as much as the fear in the air. That's the risk everyone wants to avoid. So how do you protect yourself while still standing your ground? It starts with how you talk and move. If you're driving and you're pulled over, you are legally required to show your driver's license, registration, and proof of insurance. There's no wiggle room there. Driving is considered a privilege, not an absolute right, so compliance is mandatory. Keep your hands visible on the wheel, stay polite, and don't argue on the roadside. If the officer asks you to step out of the vehicle, do so calmly, but you can still ask, am I being detained, or am I free to go? If they continue questioning beyond the traffic matter, you can say, "Officer, I'd prefer to remain silent." Remember, silence cannot be used against you, but attitude can. If you're on foot, things are a bit different. The key phrase is, "Am I being detained?" If the answer is no, you are free to walk away. If the answer is yes, you can follow up with, "Am I legally required to identify myself?" In states with stop and identify laws, you may have to give your name. If you're in a state without such a law, you can politely refuse. Either way, the best tone is calm and respectful. You can also say, "I don't consent to any searches, and I'm invoking my right to remain silent," then stop talking. Anything you say beyond that can be twisted or misinterpreted later. There have been countless real-life stories showing how these encounters go, both right and wrong. In one case, a man sitting quietly on a park bench was arrested for obstruction when he refused to identify himself, even though the officers had no reason to stop him. His charges were later thrown out, and he sued the department for violating his civil rights. The court sided with him. In another case, a woman in Texas was pulled over for a minor traffic violation. She complied with everything, but refused to let the officer search her car. The officer threatened to arrest her, but she calmly repeated that she didn't consent to any searches. He backed down. Later, her lawyer filed a complaint, and the department settled quietly. But not everyone gets justice. There are countless stories, often not filmed or reported, where refusing ID leads to unnecessary aggression. People of color, in particular, often describe the sheer fear of being stopped and questioned for no reason. The flashlight beam feels like judgment. Every word feels like a test. In those moments, the law exists on paper, but fear takes over in real life. That's why education matters so much, because knowing your rights doesn't just protect you legally. It gives you emotional control when things get tense. There are also a few common myths that need clearing up. One myth is that you can always refuse to show ID anywhere, anytime. That's not true. If you're driving or in a stop and identify state during a lawful detention, refusal can lead to arrest. Another myth is that invoking your Miranda rights means the officer has to stop asking questions immediately. That only applies if you're actually in custody and being interrogated. Street encounters and traffic stops don't always meet that standard. A third myth is that refusing always makes you safer. The truth is, sometimes compliance in the moment and then challenging it later in court is the smarter path. It's not about pride. It's about survival and strategy. Now think about what all of this really means. Picture that moment again, the flashing lights, the nervous breath, the tightness in your throat. You want to be seen as human, not as a suspect. The law gives you tools. The right to remain silent, the right to ask if you're detained, the right to refuse consent to searches, the right to an attorney. But those tools only help if you use them wisely. It's okay to feel scared. It's okay to be unsure. What matters is staying calm enough to say clearly and respectfully, I don't consent to searches. I wish to remain silent. Am I being detained? Those words spoken calmly can protect your dignity and your freedom. Knowledge is your best defense. Every time you learn one of these principles, you make yourself harder to intimidate and easier to respect. Before you travel, look up your state's stop and identify laws. Know what's required and what's optional. Share that knowledge with your family and friends, because ignorance is what law enforcement sometimes counts on. When you know your rights, you turn fear into power. So, to recap, you don't always have to show ID. It depends on whether the police have reasonable suspicion and whether your state has a stop and identify statute. The Supreme Court cases of Terry versus Ohio, Brown versus Texas, and Hiibel versus 6th Judicial District define the boundaries of those encounters. Miranda v. Arizona explains when silence becomes legally protected. Driving is different, you must show your license. But walking down the street, that's where it depends. If this story opened your eyes or made you feel more prepared for a real encounter, take a second to hit that like button. Share this with someone who needs to know it. And subscribe to The Law Explained for more truth about how the justice system really works. Drop your thoughts in the comments. Have you ever had an encounter like this? Did you know about the Hiibel case before today? Your stories could help someone else stay safe. Thanks for watching. Stay smart, stay calm, and always know your rights. This is The Law Explained, and I'll see you in the next one.